This Supreme Court term gave strong support to religious liberties in the final week, but an earlier ruling left a cloud over the future. June's ruling in the Bostock case radically redefined what sex means. Author Luke Goodrich warns that creates potential problems as the court has now made firing homosexuals or transgenders sex discrimination.
There are tens of thousands of religious organizations across the country that expect their employees to uphold their religious teachings about human sexuality. So in one sense, Bostock could greenlight a lot more lawsuits by former employees against religious employers.
Constitutional lawyer Jenna Ellis warns the ruling goes even further because it's a clear example of the court legislating from the bench.
The Supreme Court read into a 1964 law, knowing that that wasn't the intent of that Congress to define sex to include sexual orientation and gender identity. That term sex was only meant to be the biological difference between men and women. And so if the court can read into a term from a 1964 Congress, what else might they read into future legislation that damages religious liberty and free exercise of religion and the ability for Christians to follow our sincerely held religious beliefs in the future? So the precedent here is not just for employers. It's a precedent of whether or not the Supreme Court is going to give themselves overwhelming power that's not constitutional to then read into future congressional acts. And we need to protect against that.
Ellis believes Americans can do that by exercising their right to vote.
To protect religious freedom, to protect pro-life, and to protect the founding of America's principles that our rights come from God, our creator, not our government, and that it's the government's responsibility, including the Supreme Court, to continue to protect and preserve our freedoms.
Paul Strand, CBN News, Washington.